confirmed that Burkina Faso, Mali, and Niger have submitted official letters to withdraw from the Rome Statute, initiating a mandatory 1-year exit process. The three military led West African nations denounced the tribunal as a tool of neocolonial repression amid ongoing Islamist insurgencies and allegations from rights groups of atrocities committed by both militants and state armed forces. In response, the ICC presidency has warned that the move severely weakens global efforts to end impunity and undermine justice, while explicitly noting that the legal exit does not absolve any country from accountability or obligations incurred while they were a party to the treaty. Let's speak about this further with Dr. Zoumana Diarra, researcher at the University of Bamako in Mali. Dr. Diarra, thank you so much for speaking to us. What are your thoughts of what is happening? The three AES countries made it blatantly clear from the onset that they don't believe in the ICC. Is it significant that the ICC reminds them that these nations are still to be held accountable based on the acts committed while they were still a party to the Rome Statute?
Good morning. Thank you for having me. The withdrawal of the Sahelian state alliance countries, Burkina Faso, Mali, and Niger, from the ICC will not radically alter the overall military strategy, but it does confirm and accelerate a profound transformation of the operational and judicial methods on the ground.
So leaving the ICC, will that alter how these nations actually combat not only the ongoing Islamist insurgencies, but what are considered human rights violations?
The official withdrawal of those countries of IES from the ICC that doesn't legally invalidate outgoing cases, but it brings investigation on the ground to a standstill due to the breakdown in political and logistical cooperation. But I want to underline that the ICC withdrawal does not spell the end of the fight against impunity in these three Sahelian countries. Not only do national courts have a primary jurisdiction over over prosecutions, but there is also a proposal to establish a Sahelian criminal court, specially designed to try cases of terrorism and cross-border organized crime. So civilians and human rights organizations can report atrocity and other human rights violation either the National Criminal Court or eventually to the future Sahelian Criminal Courts.
So the framing of this issue has become what is really, really important, because there are those who say whether, the framing is too narrow in terms of understanding the action by the AES. Is it really witnessing a challenge of one institution, or is it really about challenging the broader post-Cold War liberal international order? All right, and it looks like we may have lost that connection. Let's see if we can pick it up again. You are listening to Rise and Shine. We're talking about the strategic action, and I suppose depending on which side of the fence you sit, of we're talking about Mali, we're talking about Burkina Faso and Niger's concerted and collective action of withdrawing from the ICC. And a lot of the argument has been about how it's viewed as carrying out its duties, the ICC that has mainly gone after African governments or African leaders. And the ICC has hit back and saying, you can withdraw all you want, but you are still liable for any transgressions that occurred while you are still a member. So the question is whether the ICC can fast track the current cases before that 1 year exit period expires. And I actually suspect that that 1 year isn't as far as people think, because as soon as these three countries formed the AES, they did express the intention and communicated it that they are withdrawing from the ICC. All right, we come now to just about 5 minutes to 8. You are listening to Watching Rise and Shine.